Hello everyone. So here's another lecture video for law talaga, Law 20023, Business Laws and Regulations. We are still in the law on partnerships, and the last topic for this portion of our course ay limited partnerships. So meron tayong isang uri ng partnership na tinatawag na limited partnership. Hindi ito yung unang pagkakataon na maririnig natin itong limited partnership na ito. Nabanggit lang actually. Hindi siya na-discuss before. Pero nabanggit na natin siya, di ba? Limited partnership with respect to the liabilities of the partners. Meaning not all partners are general partners. So limited partnership, meron diyang limited partners at meron diyang general partners. It's a combination. Kapag lahat sila general partners, then general partnership yun. Kung merong isa na limited partner, pero hindi lahat, at least merong isang general, at least merong isang limited, then that partnership is referred to as limited partnership. And as we have mentioned before, medyo protektado yung mga limited partnership in the sense that their liabilities with respect to partnership, and yung partnership liabilities ay hindi nag-extend to the personal assets of the limited partnership. Kaya siya tinawag na limited kasi limited lang yung kanyang liability doon sa kanyang capital contribution. Now, medyo mag-iiba yung format ng lecture natin for this one. Kasi medyo mahaba yung provisions ng limited partnership sa civil code, pero yung iba ay repetitive. No? Parang inulit niya kung anong... Kasi may mga bagay na applicable sa general partnership sa mga limited partnership. May mga bagay na kakaiba para lang or unique siya with respect to limited partnership. So to facilitate our study of limited partnership, we will not go through all the articles one by one kasi nga umuulit lang yung ibang articles diyan. So ang gagawin natin will be a question and answer type. Okay. So for the first slide, we are asked what is a limited partnership. So the law defines a limited partnership as one formed by two or more persons having as members one or more general partners and one or more limited partners. The limited partners as such shall not be bound by the obligations of the partnership. So yun yung binanggit natin kanina during the introduction. Yun yung definition ng limited partner. Kapag merong one or more general partners, one or more limited partners, limited partnership siya. Okay, hindi pwedeng lahat general, hindi pwedeng lahat limited. Actually, pwedeng lahat general, pero hindi siya limited partnership. General partnership siya. Pero hindi pwedeng lahat limited. No? There's no such partnership kung saan lahat sila limited partnership. Kasi that would be prejudicial to third persons, to creditors. Diba? Kasi kung ang partnership mo ay lahat limited, tapos na-exhaust na yung partnership assets, no, para bayaran yung mga partnership liabilities, wala nang mahahabol yung mga partnership creditors. So yun nga, yung unique about limited partners is that hindi sila obligado na sagutin yung mga obligations ng partnership kung sakali na kulangin yung properties or assets ng partnership. Hindi mag-extend sa personal properties nila yung obligations of the partnership. In which case, medyo, hindi naman dehado, pero nawala ng protection, nabawasan kung bagay yung protection ng mga creditors. Kasi diba, supposedly may mahahabol silang separate assets, pero with a limited partnership, merong mga partners in that limited partnership na hindi nila pwedeng habulin yung separate assets. Okay. Ito yung mga unique about limited partnership. No? A limited partnership is formed by compliance with statutory requirements. So meron siyang mga specific na requirements na sa limited partnership lamang nag-apply. No? Meron siyang mga required na mga dokumento na kailangan i-submit na hindi nag-a-apply sa isang general partnership. Mamaya makikita natin yun. One or more general partners control the business and are personally liable to creditors. So kahit na limited partnership yan, meron pa rin mga general partners na kasama. Paulit-ulit kong binabanggit, hindi maaari na ang limited partnership ay puro limited partners lamang. No? Kailangan meron silang kasamang mga general partners. One or more limited partners contribute to the capital and share in the profits, but do not participate in the management of the business and are not personally liable for partnership obligations beyond their capital contribution. So sa limited partnership, hindi maaari ng isang limited partner ay mangialam doon sa management ng partnership affairs. So ang kanilang purpose ay mag-contribute lamang ng capital. Hanggang doon lamang. They also share in the partnership profits pero hindi sila maaari na mangialam doon sa partnership affairs. They do not have that right to manage or participate in the management of the partnership. Okay? Yun yung isa sa mga limitations ng isang limited partnership. Sige na, hindi na mahahabol yung personal or separate assets mo pero hindi ka pwedeng mag-participate in the management of the partnership. Okay, the limited partners may ask for the return of their capital contributions under conditions prescribed by law. So meron natin mga sitwasyon kung saan maaaring hingin ng limited partner yung pagbalik ng kanilang capital. Then partnership debts are paid out of the common fund and the individual properties of the general partners. So sa isang general partnership kasi lahat sila pwedeng habulin. Diba? Ang gagawin ng mga partnership creditors ay habulin muna yung partnership assets and then kapag naubos na yan, then habulin natin yung mga partners, lahat ng partners in a general partnership. Including yung mga what do you call this, yung mga industrial partner. No? Bahala na sila maghati-hati internally, pero habulin natin silang lahat. But in a limited partnership, yung mga creditors, after exhausting the partnership assets, then they can only run after the general partners. So kung isa lang yan, isa lang din ang pwede nilang habulin. Kung apat. Pero for sure, yung limited partner, hindi nila pwedeng habulin. Kasi yun nga yung nature ng isang limited partner. No? Hindi sila liable. So how is the limited partnership formed? So ito yung binanggit ko kanina, meron siyang special requirements. Before there can be a valid limited partnership, the following must concur. First, there must be a certificate of articles of limited partnership, which states the matters enumerated in Article 1844. So I will not refer pwede kong i-flash actually, kung ano yung nakalagay sa 1844, but we will not read all throughout kasi medyo detalyado yung 1844. And this certificate of articles of limited partnership must be signed and sworn to by the individuals composing the limited partnership. Pag sinabing signed and sworn to, dapat dalhin mo yan sa notary public. Notarize siya. Pag sworn kasi sumpa kayo. So yung mga partners in a limited partnership must appear before a notary public and swear before that notary public. And the second, the certificate must be filed for record in the Office of the Securities and Exchange Commission. So ang gagawin natin, hanapin ko yung 1844 ng Civil Code. Okay, so we have here Article 1844 of the Civil Code. Yan. Two or more persons deciding to form a limited partnership shall sign and swear to a certificate which states the following: the name of the partnership, which should include the term limited. Diba? Sa general partnership kasi wala namang kailangan ilagay na general. No? Pero pag limited partnership yan, kailangan mong ilagay limited or the letters LTD. Anong ibig sabihin nun? Limited. Ano ngayon? Kung nakalagay doon, kanyari, X, Y, and Z, limited. X, Y, and Z and Company Limited or X, Y, and Z Partnership Limited, dapat nakalagay limited. Bakit? To inform the public agad-agad. Kunyari ako yung third person, nakita ko X, Y, and Z Limited. So I will be informed agad na itong partnership na ito ay isang limited partnership. Bakit? Dapat na-inform mo yung public na meron mga limited partners doon na in case they are interested in extending credit or in entering into a transaction with that partnership, they are already informed beforehand na merong limited partner. Meaning, hindi sila later on na magreklamo na hindi ako makapaghabol dito kay Y. Limited partner pala siya. May utang pa yung partnership sa akin. Hindi ko mahabol yung mga personal assets niya. You can say that, no, yung third person, kasi simula pa lang, alam mo na that you are dealing with a limited partnership kasi nakalagay naman sa partnership name namin, limited or LTD. Again, if the partners will fail to include limited or LTD in their partnership name, then they will be treated as a general partnership. They have to include that. Character of the business, that's common. Location, common. Name and place of residence of each member, general and limited, that's common. The term, that's common. The amount of cash, that's common. Additional contribution to be made by each limited partner. Okay, so medyo kakaiba to, yung letter G, no? To be made by each limited partner at the times at which of the happening of which they may be made. Kung kailan maaaring i-require yung mga limited partner na maggawa ng additional contribution. The time when the contribution of each limited partner is to be returned, as we have mentioned earlier, maaaring hingin ng mga limited partner yung pagbalik ng kanilang contribution. Kailan yun? Ilalagay mo dyan sa signed and sworn certificate na pinag-uusapan natin ngayon. Share of the profits or the other compensation by way of income, which each limited partner shall receive. Kung meron silang fixed na makikitain from the partnership, lagay mo yon. Kung wala, edi wala. The right, pero kung ako yung limited partner, syempre i-insist ko na meron. Diba? The right, if given, of a limited partner to substitute an assignee. So meron tayong tinatawag na substitute limited partner. We will learn about that later on. Hindi pa laging allowed na yung limited partner ay merong mag-substitute limited partner, mag-assign siya. Pero kung meron, paano mangyayari yun? Kung wala, hindi wala. Kung meron, ilagay mo sa certificate. Then sunod, the right if given of the partners to admit additional limited partners. So kung yung right to admit additional limited partners is not generally granted, but if they want that right to be given to them, they have to include that in the certificate. The right, if given, of one or more of the limited partners to priority over other limited partners. So if they want to have this priority, then they have to include that in the certificate. The right, if given, of the remaining general partners to continue the business of the debt, retirement, or civil interdiction, insanity of a general partner, and the right of a limited partner to demand and receive property other than cash. So yung mga bagay na yan, kailangan ilagay doon sa certificate, and they have to file that with the Securities and Exchange Commission. Okay? So, nakalagay din mismo sa civil code natin that strict compliance with the legal requirements not necessary. It is sufficient that there is substantial compliance in good faith. So similar to the formation of a general partnership, bandang simula ng ating discussion, meron tayong tinatawag na de facto partnership. So even if they have complied with all the requirements, almost all the requirements, pero meron pa rin kinulang, not all of the legal requirements were complied with, ang tawag sa kanya ay de facto partnership, and the liability will still attach in order to protect the interest of the creditors or the third persons. Ganun naman kasi palagi. Kasi kung magiging ano ka dito, strict ka dito, pwede nilang sabihin na we did not comply naman with all the requirements, so there is no partnership to begin with. So mawawalan pa ngayon ng habulin yung mga third persons and mga creditors. just on that notion, parang mas magiging magiging beneficial pa sa kanila na hindi sila sumunod with the requirements of the law. So even if they have not complied with all, but they have substantially complied with all, meron namang substantial compliance, then it will not affect yung yung legality of the partnership, but they will still be required to comply naman. And then ito medyo special with respect to a limited partner. The contributions of a limited partner may be cash or property but not services. So bawal ng isang limited partner ay mag-contribute ng services. Dapat ang i-contribute niya ay cash or property. Kasi pag nag-contribute siya ng service, again, makasama siya dun sa affairs ng partnership, madi-disqualify siya bilang isang limited partner. If you have to think about it, a limited partner is a capitalist siya palagi. Pondo lang ang palagi niyang pinoprovide sa isang partnership. Never siya magpo-provide ng serbisyo. Kapitalista lang siya, kumbaga. Taga-investor. Para siyang investor. Isipin mo parang investor ang mga limited partners. Okay. Ito naman, similar siya. Similar to a general partnership, a limited partnership acquires separate juridical personality. So ganun pa rin, yung discussion natin on separate juridical personality will apply with respect to limited partnership. So, meron pa rin silang personality which is distinct and separate from that of the partners which composes them. So, ito binanggit hindi pala ito nabanggit. The surname of a limited partner shall not appear in the partnership name. So, medyo kakaiba uli ito. Sabi natin, kapag ikaw ay partner in a partnership, you may or may not allow your name to be included in the partnership name. But if you are a limited partner, you are not allowed to include your name in the partnership name. Bawal yun. A general partner may or may not. Pero a person who is not a partner should not allow his or her name to be included in the partnership name. A limited partner whose surname appears in a partnership name is liable as a general partner to the partnership creditors who extended credit to the partnership without actual knowledge that he is not a general partner. So ganun, kapag in-insist ng isang limited partner na yung apelido niya ay isama doon sa partnership name, then that limited partner will have the liabilities and obligations of a general partner. Huwag kang makulit, sabi. And then a person may be a general partner and a limited partner in the same partnership at the same time, provided that this fact shall be stated in the certificate. So merong partner na maaaring mixed yung kanyang personality, dual yung kanyang personality. General partner siya at the same time limited partner. As long as that is provided in the certificate na binanggit natin kanina, nilabas natin yung provision provided by the Civil Code. So ano ngayon yun? Anong effect nung ikaw ay general at the same time limited partner? A person who is a general and also at the same time a limited partner shall have the rights and powers and subject to all the restrictions of a general partner, except that with respect to his contribution, he shall have the rights against the other members, which he would have if he were not also a general partner. So technically, yun yung kanyang makukuhang part as a limited partner. Hindi maaaring ipanagot yung kanyang separate properties para sa satisfaction ng mga obligations or liabilities ng partnership. Yun yung portion na siya ay limited partner. But with respect to all the rest, siya ay general partner na. Pero yun nga, pag ang pinag-uusapan na is how to settle yung partnership liabilities, pwede niyang i-invoke na siya ay isang limited partner at hindi maaaring gamitin o habulin yung kanyang separate or personal properties to satisfy unsettled partnership liabilities. What are the liabilities of a limited partner in a limited partnership? So a limited partner is considered a creditor insofar as deficiency in contribution and unpaid contributions are concerned. Tandaan, ang limited partner ay isang kapitalista. Isa siyang kapitalista, siya ay taga-contribute ng pondo. So in effect, kung ang pinag-uusapan mo ay yung deficiency niya, actually applicable din naman to sa mga general partners. Diba, if they have promised to contribute cash, then with respect to that contribution, they are considered as creditors. So dito, inulit lang naman yan, a limited partner is considered as a creditor insofar as the deficiency in contribution and unpaid contributions are concerned. So kapag nangako siya na limited partner, wala namang ibang pwedeng i-contribute ang isang limited partner kundi cash or property, kasi hindi niya pa na-contribute yon or na-contribute niya pero kulang, with respect to those unpaid or insufficient contribution, the limited partner is treated as a credit. Tawag dito. Baliktad to, no? Debtor dapat siya. A limited partner is considered as a debtor insofar as deficiency in contribution and unpaid creditors are concerned. A limited partner is considered as a trustee naman insofar as specific property stated as contribution but not yet contributed, wrongfully returned, and money or other property wrongfully paid to him on account of his contribution are concerned. So, kapag nagbigay ka sa kanya ng property pero hindi pa naman due or owing sa kanya yung contribution na yan, he is treated as a trustee. No? Trustee yung kanyang capacity. So, ibig sabihin, ang tawag dito, ang limited partner ay maaaring itignan bilang debtor or bilang trustee. A limited partner is also allowed to grant loans to the partnership. So, maaari siyang magpautang, so maaari siyang mag-assume ng position bilang isang creditor. This is also allowed sa isang general partner. A general partner may also extend loans to the partnership. So yung general partner may assume the position of or the capacity of a creditor. Diba? Sa liquidation na, we learned that after settling the creditors of the partnership, yung next in the order of priority ay yung mga utang ng partnership doon sa mga partners in their capacity as creditors. So a limited partner may also do that. May also extend loans to the partnership. Ito yung kakaiba sa limited partner. The limited partner may transact business with the partnership. Di ba? Parang kakaiba to. Kasi sa mga general partners, parang conflict of interest ito eh. Dito, the limited partner, him or herself, may transact business with the partnership without giving rise to a conflict of interest. So pwedeng ang katransact ng partnership ay yung limited partner mismo. And a limited partner may receive his pro rata share of a partnership assets with general creditors if he is not also a general partner. So kapag ganyan, kapantay ng limited partner yung mga creditors in case of distribution ng partnership assets. So medyo prioridad ang mga limited partner kapag nag-distribute ka na ng partnership assets. Pero kung siya ay general partner din, hindi niya pwedeng i-invoke ang right na ito. How is a limited partnership managed? Paano ba natin i-manage yung limited partnership? We have discussed doon sa general partnership kung paano ma-manage ang isang limited partnership. Okay. A general partner, may general partner in a limited partnership. A general partner shall have all the rights and powers and be subject to all the restrictions and liabilities of a partner in a partnership without limited partners, as if walang limited partner doon. However, di ba meron kang, kunyari, 5 sila, may 2 general partner, isa na lang, isang general partner, 4 na limited partners. So itong general partner na ito, bukod tami, will have the rights of all a general partner as if wala yung mga limited partner na yan. So kung ano yung mga karapatan ng isang general partner in a general partnership, the same rights na meron sila kung ang mga kapartners nila ay mga limited partners. Okay, pero ito yung volatility. Itong general partner na ito ay hindi maaaring gawin ang mga sumusunod na gawa. Meron tayong mga enumeration dito nang hindi hinihingi ang consent ng mga limited partners. So, ibig sabihin, meron to a certain extent, ang mga limited partners ay meron pa rin say doon sa partnership affairs. Pero kapag ito lang ang mga sumusunod, ang pinag-uusapan. Una, do any act in contravention of the certificate. Diba, we have discussed earlier na meron kang certificate of partnership na kailangang pirmahan at sumpaan. Kung merong gagawin yung general partner na medyo kumukontra doon sa certificate of partnership na yan, kailangan ng consent ng mga limited partners. Pangalawa, do any act which should make it impossible to carry on the business of the partnership. Bakit? Kasi this one will result into the dissolution of the partnership. And the limited partners do not want that. Di ba? Kung ako yung limited partner, nag-contribute na nga ako, hindi ko na nga ma-manage yung affairs ng partnership, tapos gagawa ka pa ng mga bagay na that may result into the dissolution of the partnership. Wag mong gagawin yan unless we will consent, the limited partners will consent. Confess a judgment against the partnership. Again, this one is prejudicial to the partnership. Malalagot yung partnership if they will allow the general partner to confess judgment against the partnership. Tandaan, against the partnership. If this one will be in favor of the partnership, then okay lang. Kasi favorable din sa partnership. Pero kung meron siyang i-confess which would be prejudicial to the partnership, then hindi pwedeng gawin ni general partner yan without the consent of all the limited partners. Fourth, possess partnership property or assign their rights, specific partnership property for purposes other than partnership purposes. Siyempre, may say pa rin ang mga limited partners doon sa paano i-manage yung partnership property. So yung possession ng general partner dapat with the consent of all the limited partners. Or the assignment of rights and specific partnership property should also bear the conformity of the limited partners. Pag property na ang pinag-uusapan, medyo interested dyan yung mga limited partners. Siyempre sila yung contribute niyan. Although hindi naman sinasabi na walang contribution, yung general partners, tandaan, kapitalista ang mga limited partners and everything that will affect the properties of the partnership they are interested in doing. And they have their interest doon sa partnership properties. So in any case na merong possession ng property or assignment of rights and specific partnership property, required na mag-consent yung mga partners if yung possession na yan or yung assignment na yan ay hindi tugma doon sa purpose ng yung possession or yung assignment ay hindi tugma doon sa purpose ng partnership which is stated in the certificate. That is item number 2 doon sa certificate nila. Admit another person as a general partner. Siyempre, medyo ayaw nung mga limited partners na merong additional, not really ayaw. No? Not really ayaw. Pero kapag merong ina-admit na additional general partner, dapat merong consent ng mga limited partners. Admit a person as a limited partner unless the right so to do is given in the certificate. Meron din sa certificate na binanggit natin kanina na karapatan na mag-admit ng limited partner. Kung nakalagay na yun doon, then wala na, hindi na kailangan pang magsalita ng mga existing limited partner. Pero kung walang nakalagay doon sa certificate about the admission of new limited partners, then any admission of new limited partners should have the consent or should obtain the consent of the existing limited partners. 7, continue the business with the partnership property upon the death, retirement, insanity, civil interdiction, or insolvency of a general partner. So dito, kapag ang general partner ay namatay, nag-retire, na-insane, or civilly interdicted, or naging insolvent, it will cause a dissolution of the partnership. They may continue. We have discussed this before. They may continue with the business of the partnership. Kapag nag-continue yung business, syempre magde-decide dyan yung tawag dito, yung general partner. Pero hindi siya pwede mag-decide on his own if hindi yan nakalagay dun sa certificate. If nakalagay na sa certificate, then so be it. Kasi parang nag-agree na beforehand yung mga limited partners. Alam na nila sa start pa lang na kung sakaling magkaroon ng death, retirement, insanity, etc., etc., Merong karapatan itong general partner na ituloy yung business. Pero kung wala, then kailangan mag-consent ng lahat ng limited partners. Okay? So those are the decision items or matters na kailangan mag-decide kasama yung mga limited partners. So generally, hindi sila pwedeng mag-decide. No? Hindi sila part ng management ng affairs ng partnership. Pero with respect to those matters that we have discussed, kailangan may say yung limited partners. What are the rights of a limited partner? Yan. First, no, just like any other partner, they have the right to receive a share in the profits and other compensation by way of income and to the return of his contribution. Siyempre, dito mas interesado yung limited partner. Kaya nga ako nagbigay dyan, nagbigay ng pondo or ng capital, siyempre I have this expectation na makareceive ng profits. Hindi na nga ako naghahabol doon sa partnership, management of the partnership, or di ko na, kahit wag nyo na nga akong ilagay as part of the partnership name, pero bigyan nyo naman ako ng share in the profits. Just like a general partner, yung limited partner, lalo na ang limited partner, bigyan mo siya ng share niya dun sa profits. Karapatan din ng isang limited partner na ma-maintain, no, to have the partnership books kept at the principal place of business and yung right niya to inspect and copy them. Siyempre, interested yung limited partner kung paano maginagastos yung pera na kinocontribute niya. Diba? Hindi niya na ma-manage yung pera niya eh. Kasi wala siyang say in the partnership affairs except for those matters na binanggit, kakabanggit lang natin. Pero yung general na pag-operate ng partnership, walang say yung limited partner doon. Pero kailangan alam niya paano ba ginagastos or saan ba napupunta yung perang kinontribute ko. So to do that, kailangan i-maintain yung partnership books doon sa principal place of business of the partnership at dapat may karapatan din yung limited partner na within reasonable hours to inspect and then to copy yung contents ng books ng partnership. It is also the right of a limited partner to have on demand true and full information of all the things affecting the partnership. Any formal account of partnership affairs whenever circumstances render it just and reasonable. Again, we have this principle na yung limited partner ay kapitalista. No? Interested lang siya palagi. Paano ba minamanage yung, wala siyang say, pero paano ba minamanage yung finances nung partnership? I need to know. So kapag nag-demand siya, kailangan i-provide ng general partner yung true and full information on how the affairs of the partnership has been managed. And even formal accounting. Ganito na po yung nangyari sa pera ninyo, etc. etc. Then, the limited partner shall also have the right to ask for the dissolution and winding up upon decree of court. Kailangan niya pumunta sa korte if gusto niyang exercise yung right na yon to ask for the partnership dissolution and winding up of the affairs, liquidation. Okay, that's it. Yun yung mga rights ng isang limited partners. Okay, limited partner. Who is a substitute limited partner? Kanina, dun sa may certificate of partnership na pinag-usapan natin, meron dun nakalagay na right na yung limited partner magkaroon ng substitute limited partner. Magkakaroon lang yan if nakalagay dun sa certificate of partnership. Kung wala, walang karapatan to have a substitute. Kung meron, ito siya. Who is a substitute limited partner? A person admitted to all the rights of a limited partner who has died or assigned his interest in the partnership. So dalawa yung maaaring sitwasyon para magkaroon ng substitute limited partner. Una, mamamatay yung limited partner. Pangalawa, or inassign yung limited partner yung interest niya in the partnership to that substitute. So dalawa, namatay or nag-assign. Death or assignment. Uy, naiwan yung bilog. What are the rights of the substitute limited partner? The substitute limited partner shall have all the rights and powers and is subject to all the restrictions and liabilities of his assignor who is the limited partner, the original limited partner. So kung ano, meron karapatan at obligasyon yung limited partner na nag-assign sa kanya, yun din ang magiging karapatan at obligasyon nitong substitute limited partner. except that the substitute limited partner is not liable for liabilities, which he was ignorant of at the time he became a limited partner. So, syempre, yung mga hindi nila alam, hindi dapat ipataw sa kanila bilang obligasyon. They did not know of those obligations, then they should not be held liable for that. How can there be a substitute limited partner? Para magkaroon ng substitute limited partner, all the members must consent to the assignment, no? And the assignee becoming a substitute limited partner, or the limited partner being empowered by the certificate must give the assignee the right to become a limited partner. So including yung mga general partners, they must consent to an assignee becoming a substitute limited partner. If they will not consent, then hindi maaari na yung assignee ay magiging substitute limited partner. The certificate must be amended. So yung original certificate that they filed with the SEC must be amended by filing an amended certificate. And the certificate as amended must be registered again with the SEC. And then last question, how is a limited partnership dissolved? So the retirement, that insolvency, insanity, or civil interdiction of a general partner dissolves the partnership. Okay. Unless, ibig sabihin kapag yung limited partner, hindi siya madidissolve. Kung meron pang may iwan na limited partner. Pero kung isa lang siya na limited partner tas namatay siya, then syempre wala na yung limited partnership. Unless the business is continued by the remaining general partners under a right to do so, stated in the certificate, nakalagay dapat certificate of partnership nila, na kapag isang general partner ay nag-retire, namatay, naging insolvent, na insane or civilly interdicted, meron silang karapatan na i-continue yung business. And then, with the consent of all the members. Kung lahat naman papayag, even if hindi siya nakalagay dun sa certificate of partnership, if everyone will consent, then okay lang na ituloy nila kasi consent naman. Upon the death of a limited partner, his executor or administrator shall have all the rights of a limited partner for the purpose of settling his estate and such power as the deceased had to constitute his assignee as a substitute limited partner. Pag namatay yung isang limited partner, nagkakaroon ka ng executor or administrator. Siya yung magmamanage ng properties ng namatay na limited partner. Tapos, based on our discussion earlier, maaari siyang maging substitute limited partner. Magiging substituted limited partner siya. At kapag naging substituted limited partner siya, he or she will acquire the rights and obligations of the limited partner who has died. The estate of the deceased limited partner shall be liable for all his liabilities as a limited partner. Siyempre, yun nga, actually hindi lang liabilities, pati naman yung rights ay makukuha niya. Okay, in settling the accounts after the dissolution of the liabilities of the partnership, ito yung order of payment natin. To the creditors, in order of priority as provided by law, except those to limited partners on account of their contributions, and to the general partner. So the unang, in the order of priority, kapag nag-liquidate ang isang limited partner, just like a general partnership, uunahin mo yung outside creditors. Pangalawa, those to limited partners in respect to their share of the profits and other compensation by way of income or contribution. So pangalawa yung mga limited partners. Pangatlo, limited partners with respect to their capital. Uunahin mo pa rin yung capital ng limited partners. Pang-apat, general partners with respect to their claim as creditors. Pang-apat, general partners with respect to profits. And pang-anim, general partners with respect to their capital. Check nyo yung difference. Kapag general partnership, una yung outside creditors, and then the general partners in their status as creditors, general partners with respect to capital, and general partners with respect to profit. So dito baliktad siya. Anyway, uunahin mo pa rin kapag limited partnership ka, uunahin mo pa rin yung outside creditors and then limited partners with respect to their profits and contribution. As creditors, limited partners with respect to their capital, general partners as creditors, general partners with respect to profits, and general partners with respect to capital. Okay, that's it. Tandaan nyo lang yung mga kakaiba sa mga limited partnership. Medyo mahaba itong provision na ito sa civil code, pero kung magpo-concentrate ka lang dun sa mga unique, sa mga limited partners, you can manage your learning pagdating sa limited partnership, as we have done with this lecture video. Okay? Thank you for listening and see you. Actually, end na to ng law on partnership, but we have another topic to discuss, and that is credit transaction. See you on the next lecture video. Thank you for listening. Bye-bye.